There are two somewhat related mistakes that California employers sometimes make that can be quite costly if they turn into a claim or a lawsuit. The first such mistake is not believing their employee who asks for medical leave just because. Not believing because the employer thinks that the employee is lying, he's trying to take advantage and game the system, when in reality that employee does have a legitimate reason, a legitimate medical condition that makes him entitled to that leave. And the second mistake is assuming that you, the employer, can override what the employee is entitled to by law with your own policies and with what you think is reasonable. The recent case that came out of Tulare County in August of this year, in August of 2021, is a good example where the employer made both of those mistakes and paid a lot of money because in this case the jury awarded the employee $1.2 million. So here are the brief facts, and after I talk about the facts, I will also talk about how these two mistakes probably played a role in this case, in the jury's reaching their verdict. So, plaintiff, the employee, worked for Porterville Unified School District since 1998 as a custodian, and he was in his 60s at the time of his termination. So, you have an older gentleman who worked for this employer for over 20 years. Of course, all things equal, if he's terminated, the jury will conclude that this event, this termination, had a far more challenging or even devastating effect on his life than someone who is younger and someone who only worked for that employer for a few years or even less. During his employment, he was diagnosed with diabetic peripheral neuropathy. Sounds like a serious illness to me. In or around May 2017, he spoke to his medical provider about his medical condition, and the two agreed that a medical leave was appropriate. During plaintiff's 5-week medical leave, the defendant, the employer, discovered that plaintiff was out of the country and demanded that he return to work within less than 24 hours. Defendant then invoked an automatic resignation process, or AWOL, and terminated plaintiff's employment. So, how do these two mistakes that I mentioned earlier, how do they play a role in this case? Well, you have an employee who has a serious health condition. He gets a medical approval to take medical leave. He gives that paperwork from his doctor to his employer. The employer knows that this employee has a legitimate right to take medical leave. The employee goes out on leave, and the employer somehow finds out that that employee is out of the country. Maybe they checked out his social media and saw some pictures or his activity overseas, and the employer probably automatically assumed that the employee lied about needing medical leave, and instead he just takes this time to travel and to enjoy himself, without even thinking that there could be other reasons why the employee is overseas. Maybe his doctor told him that he should go overseas. Maybe his doctor recommended that he should go overseas for stress relief. Maybe the employee went overseas to seek some medical treatment that he could not get back home in the United States. There could be some other legitimate reasons why that employee was traveling. Not to mention the fact that just because you're on medical leave doesn't mean that you have to be bedridden and that you cannot leave your house, your city, or even your country. There is no such law. And the second mistake is the fact that the defendant, the employer, somehow decided that, hey, I think that employee is lying, and I'm going to give him 1 day to come back to work. Even though I know that he's on medical leave for 5 weeks, I'm going to give him 24 hours, not because the law says, but because I say so. And if he doesn't return back to work, I'm going to terminate him, or I'm going to have him deemed resign, because this is my decision. Nowhere does it say in ADA or in California Fair Employment and Housing Act that the employer has the right to demand that his employee returned to work early from medical leave, let alone within 24 hours. So, of course, employers cannot override the law with their own policies. So, you have two mistakes here happening at the same time. The employer assumes that the employee was not truthful about needing medical leave, and then the employer, on top of that, creates their own stringent return to work policy that doesn't exist in the law, that is not supported by law. I was not present during the jury deliberations. I did not talk to the jurors. This is not my case. This is a case that was handled by one of my good friends. But I can imagine that these two factors played a role in this case. They angered the jury and they led to this fairly significant award, $1.2 million. So what is the lesson here for employers? Well, unless you have a really, really good reason, don't assume that your employee is lying about trying to exercise his or her disability rights or medical leave rights. At least give them the benefit of the doubt. Talk to them. Find out why they are not where you expect them to be. In this case, if the employer reached out to this employee and asked, hey, why are you overseas? What's going on? Maybe the employer would have found out what's going on. Maybe the employee would say, listen, this is confidential. I'm here for medical reasons. I do not want to disclose that. Who knows what would have happened? But having that conversation before assuming that the employee is lying would be a good idea. And the second lesson is knowing and keeping in mind that there are laws out there that provide for specific workers' rights, that you cannot override with your own rules and your own policies. And your attorney should be able to advise you whether you can implement certain policies or whether you cannot, because such policies would go against the existing law. And the law almost always prevails. It almost always supersedes companies' internal rules and procedures. Thank you for watching.